Okay, we have almost everybody here. So I don't know if we want to just wait 3 more minutes and then we'll get started.
My sense, Nova, is that because this has been agendized, right? That we ought to start it at the time agendized.
Oh yeah, that's right.
Yeah.
Hi, Nova, it's Kelly. Can you hear me?
Yeah, I can hear you.
I just have a quick question. I noticed the chat is disabled. So if there's a question at any point, do you want us just to use the raise hand?
Yeah.
Okay. Thank you.
Yeah, no problem.
And Nova, if you want me to answer questions during the presentation, I can do that. It may be a little difficult if we spend too much time on questions to get through all the material. But I like doing an interactive approach, but I think everybody should just realize I may be kind of clipped with my answers so that we can get through all the material required for this training.
Okay. Yeah, that however you want to do it is fine.
And I can be available afterwards too if people aren't fully sick of hearing me talk.
Yeah, we can also do more questions at the end, so that if people have, additional things, that's fine.
Yeah, good.
And Nova, for people who couldn't attend this morning, will this be available online, or is there a place that they can do it separately?
Yeah, I mean, you can watch it later. You won't get the certificate though, because you have to be live on this meeting the full 2 hours to get the certificate. But if anybody can't make it today, there is another option through the FPPC where you can do a training online through their website.
Did you, for Forest and Beach, are we missing anybody?
Let's see. I think the only person I don't see is, oh wait, no, Hans is here. Sarah Burling wasn't going to make it today. She was going to do it separately, but everybody else is here.
Okay, thank you so much.
Okay, so I think we can get started. It's 10:02 right now. So this is the ethics training for the city of Carmel-by-the-Sea. And Tom Brown from the City Attorney's Office will be conducting this training.
Good morning, everybody. Again, my name is Tom Brown. I work with the law firm of Burke, Williams, and Sorensen, which is the law firm that provides your city attorney services. We have a lot of material to cover, and some of the areas I will be kind of zipping through. I'll do my best to answer questions, as I've said, and we may end up having to maybe put off some of the questions till afterwards. So welcome, and thanks for joining me. So AB 1234 is why we're here. AB 1234 is a statute that was adopted in California in 2006. It was in response mainly to a scandal involving the city of Bell in Southern California. The people you are looking at in these mugshots are city council members and the city administrator, all of whom did substantial prison time and paid substantial fines as a result of what was really a true scandal involving graft and corruption in the city of Bell that largely went unnoticed for a long time. But to give you just sort of a flavor of it, at the time that it became discovered, the city manager in Bell, through his own efforts to line his own pockets, was paying himself, or had the city paying him nearly $1 million a year for a relatively small city. As I'm sure most of you can appreciate, that is a breathtaking amount of money. And that scandal ultimately led to the adoption of AB 1234, which, among other things, requires that public officials do this 2-hour training every 2 years. We will be talking a good deal today about the Fair Political Practices Commission, which is the state agency that was formed in roughly 1974 after a statewide initiative was passed creating the Political Reform Act. The FPPC is responsible for enforcing not only the Political Reform Act, but also Government Code Section 1090. I will be covering both of those later. This is what the FPPC posts on its website. They call it the heat map. The heat map is a map that shows all of the prosecutions that the FPPC has and enforcement proceedings that the FPPC has made every year. You can go to it, you can click on your county, and you can see what public officials in your county and other counties have had violations enforced against them. It is a very public map, and it gives you a flavor that what we're talking about here today is very real and very serious. So one of the things that you should keep in mind, one of the takeaways from this training, is that the laws I'm going to be talking about are complicated. Every year, my group of city attorneys get together twice a year, and we have regular sessions involving these conflict rules. And I can tell you that many of these rules leave many of us who have been practicing in these areas of law for many, many years scratching our heads. So for public servants, some of it is just impenetrable, and it becomes very important that you try to get legal counsel as soon as you can possibly get it. And there are ways that you can try and forecast when issues will arise, but do try to get advice on some of these matters. You can also get advice from the FPPC. There, you can either get informal advice or formal written advice. Now, as you do seek advice from your city attorney, remember that under the rules of professional conduct that the state bar imposes on us as attorneys, your city attorney represents the city of Carmel-by-the-Sea as an entity and not you personally. And therefore, you should be aware at all times that you do not have an attorney-client relationship with your city attorney, nor do you have any expectation that the conversations you have with your city attorney will be confidential. That relationship doesn't exist. It only exists between the city attorney and the city itself. In addition, reliance on advice from legal counsel, your city attorney, is not a defense if your actions result in a violation. As I said before, you can seek advice from the Fair Political Practices Commission, and only formal advice from them, not their informal advice, will protect you against enforcement proceedings for violations of the FPPC regulations. So today, as we are gathered here, and if we do get a chance to have you ask questions about the conflict rules and about open government and transparency rules, please try to make your questions hypothetical. I do want to try and prevent situations from, where your personal experiences are in play. As I say here, let's not confess to any violations here if possible. All right, what are we going to try and cover today? Here's our agenda. First, I'm going to get into the California transparency laws. They are mainly the Ralph M. Brown Act, which is the open meeting law in California. And then secondly, the Public Records Act. Second, I'm going to get into personal financial interests and fair processes. These include conflicts of interest rules under the Political Reform Act, common law conflicts, including personal interests and bias, contractual conflicts of interest under Government Code Section 1090, and fair process rules that will apply to some of your proceedings. Finally, I'm going to talk about legal limitations on perks and advantages of office. What are we trying to accomplish here today? One, we want you to familiarize yourself with the laws that govern your public service and when you should ask questions. Again, I think that will be your most important takeaway today, is to try to be educated enough to know when to ask questions and what might be creating a legal issue for you. Two, the purpose of this is to encourage you to think beyond legal restrictions, outside the box. What does this mean? It means that what we're going to be talking about today mainly are the floor, the basic rules that govern what you do. But I think it's important to recognize that what we're trying to do in all this is to increase the public's trust and confidence in us as public servants. And there will be times when you may decide for yourself, well, my participation here is perfectly legal, but there is an appearance here that I don't think will elevate the public's trust and confidence in what I'm doing. And you may decide on a purely voluntary level that you're not going to participate. Now, as you make that decision, it's important, obviously, to recognize that that you, if you are an elected official, have a competing duty to represent your constituents. And in addition, if you are appointed officials, commissioners, board members, et cetera, you also have an obligation to fulfill the roles of your office, fulfill your duties in your positions. But recognize as well that when I tell you that the law applies, you have no choice. You do need to conform yourself to those laws. But again, those laws should be viewed as a floor, not a ceiling. Finally, what we're trying to accomplish here today is to allow you to satisfy the requirement under state law, AB 1234, that you engage in this training every 2 years. Okay, first thing we're going to cover are the transparency laws. The Brown Act, it was adopted in 1954, and at its heart, it says that public commissions, boards, and councils, and other public agencies in the state exists to aid in the conduct of the people's business. It is the intent of the law that their actions be taken openly and that their deliberations be conducted openly. Now, what is that? What is the heart of the Brown Act to try and accomplish that purpose? The Brown Act requires, very simply, that all meetings of a legislative body of a local agency must be open and public. And two, all persons must be permitted to attend any meeting. We're going to talk about each of these elements as we go through our discussion of the Brown Act. The basic rule: meetings of a legislative body are covered by the Brown Act. What is a legislative body? Well, clearly it's your city council. It is also any board or commission created by formal action of the city council. That includes standing committees or commissions. An advisory committee of the city council made up of less than a quorum is not a legislative body. That is by statute as well. There are some instances in which a private nonprofit entity can constitute a legislative body covered by the Brown Act. I'm not going to get into that in too much detail, but typically that situation arises where the private nonprofit has been formed by or at the behest of the public agency and receives substantial funding from the public agency, and typically will have one member of the legislative body designated as a voting member of that nonprofit, of the private entity. Okay, what is a meeting? We've covered what is a legislative body very briefly. And I will say as well that there are hundreds of cases dealing with all of these issues that involve nuances in these rules. And I'm not going to get into too much of that today. This is really an overview of the law, and it's not intended to be a real in-depth study of where the case law has taken some of these principles. What is a meeting under the Brown Act? A meeting is any gathering of a majority of the members of the legislative body at the same time and location to hear, discuss, deliberate, or take action upon any item which is within the subject matter jurisdiction of that body. Now we're going to be discussing some of the exceptions to this, which are created both by case law and by statute. For example, there are principles that we're going to talk about of serial meetings, where all of the majority of the members don't need to be in the same place and at the same time, and a meeting will still exist. In addition, the Brown Act's definition of meeting says that when the gathering occurs, it doesn't need to take action for the meeting to exist. In other words, if you are hearing or discussing or deliberating or taking action, that constitutes a meeting under the Brown Act. Okay, the most recognizable form of meeting under the Brown Act is a formal meeting. And there are three different kinds of those specified under the Brown Act. There are regular meetings. Those have to be, those are the meetings that you attend and do your business in by some formal rule. For example, a city council is required to adopt a regular meeting date and schedule for those meetings, and as are boards and commissions that are created by the city council. For those meetings, notice in the form of an agenda has to be posted 72 hours, 3 days before the meeting occurs. There are also what are known as special meetings. These are meetings that are typically conducted on shorter notice, 24 hours notice, to attend to or address one or two or more specific issues, but are not your general meetings where all city business is conducted. Finally, there are emergency meetings, which can be noticed with as little as 1 hour notice to the media. it's going to be pretty rare that emergency meetings will be used, but the Brown Act does allow for them. The Brown Act also allows for meetings to be conducted by teleconference. That is where one or more members can participate from a remote location by electronic media. These teleconferencing meetings are subject to fairly strict rules. The normal teleconferencing rules that have been in existence for many, many years under the Brown Act require that an agenda be posted at all locations with teleconference locations specifically identified. What does that mean? That means if you are teleconferencing, if you have decided to participate in a meeting from your hotel room in New York City, your hotel room needs to be noticed. Second, all teleconference locations must be open to the public with public participation at each location. So that puts a dent into your hotel room in New York City, because now most hotels have an electronic key requirement in the elevators to get you up to a second floor. So unless your room is open to the public at each location, you need to coordinate with your hotel and use a conference room that is truly open to the public. The agenda needs to be posted there. Now, I've been doing this, by the way, for 40-some years, and I've never once heard of any member of the public actually showing up at a remote location, but it is the law, and you got to comply with it. There has to, under the regular teleconferencing requirements, a quorum of the legislative body must participate from locations within the jurisdiction of the city. And votes have to be by roll call vote when teleconferencing is occurring. These are the normal rules that existed long before the pandemic, which gave rise to very different teleconferencing needs and thus rules. So there is also now a law that was passed in response to the lockdown and the pandemic. AB 361 allows for emergency teleconferencing. Under AB 361, meetings may be held remotely without observing normal teleconferencing requirements, the ones I just described, if all the above have been met. If there is a statewide state of emergency and state or local officials have imposed recommended social distancing measures, or meeting in person would present imminent risks to the health and safety of attendees. We all saw this during the early days of COVID and the lockdown. To use AB 361, the City Council must pass a resolution making the findings listed above. In addition, there are now new teleconferencing rules adopted in the post-COVID years. AB 2449 creates a limited right to teleconference if two circumstances exist: either just cause or emergency circumstances. Those terms are defined under AB 2449. Just cause is defined in the statute as including childcare or child giving, contagious illness, physical or mental disability, or travel for public business. The procedures for invoking the just cause teleconferencing opportunity are you must notify the legislative body, your commission, or if you're on the city council. I don't know if we have city council members attending today, or the council. Notify whatever legislative body at the earliest opportunity and provide general description of the circumstances constituting just cause. Let me go back. So you'll see, for example, that contagious illness is one of them. I think the Brown Act doesn't, this new statute doesn't really address how much detail you're required to provide. I imagine that there are some privacy circumstances that would be implicated here. I think that may play out in litigation that we may see over years to come. That's the kind of stuff that I have to deal with as a Brown Act lawyer. In addition, under this just cause exception, it can only be invoked less than 2 meetings per year, and there are other temporal limitations. If you want to try and use this, I suggest you coordinate with the city attorney in advance, or the city clerk, or both. So under 2449, as noted, there are also emergency circumstances that can allow for remote participation. Emergency circumstances are defined to include a physical or family emergency, medical emergency that prevents a member from attending. There are, as with the just cause requirements, there are procedures. You have to provide a description, no more than 20 words, and no personal medical information, and request. Here, you need to request that the legislative body allow the remote participation. There are no standards or rules under this as to whether and under what circumstances your legislative body may be required to allow your remote participation. I would view it as, in the absence of any such rules or standards, the commission or council is under no obligation to grant the request. And in that situation, teleconferencing under this emergency circumstances prong would not be allowed. Other rules for the emergency circuit for either, the meeting must be conducted using both audio and visual technology for the remote participation. This is different from the way it's been done under the regular rules for years, which is just a telephone and a speakerphone in the council chamber somehow, or the commission room would be sufficient. Here, there has to be both audio and visual technology. Remote participants must disclose anybody else in the room with them over 18, the city must provide notice and a way for the public to remotely hear, observe, and remotely address the body. This was not the case previously. Call-in, internet, and in-person participation must be allowed. The city may not require advance comments and must provide a live option. And I think most importantly, if the technology is disrupted during the meeting, you got to stop. No further action can be taken until the technology is restored. Another recent Brown Act amendment was Senate Bill 1100. This doesn't deal with what constitutes a meeting or how you do a meeting, but it really gets to the rules for removing disruptive individuals from a meeting. This statute really is consistent with what federal law has held for many years as to under what circumstances you can interfere with someone's First Amendment rights and remove them from a meeting. There's a lot of law on that. But under the Brown Act, the chair may have an individual removed for, quote, disrupting, end quote, a meeting. The chair must warn first that the behavior is disruptive and that removal may result if it continues. This warning requirement obviously doesn't require if there is actual force or threatened force being used. In other words, common sense does not go out the window here. If someone is actually threatening anybody or using violence or force, the meeting, they may be removed. Behavior is disruptive, and this is again consistent with federal First Amendment law. Now, behavior is disruptive if it actually disrupts or impedes the orderly conduct of the meeting. This is an area you have to be really careful, and it goes along with the fact that the Brown Act specifically and expressly allows members of the public to criticize us. They may criticize us. They may tell us either collectively or individually we are doing a terrible job. When you engage in public service, you have to sort of check your ego at the door, and you have to develop a thick skin because the public has a right to criticize us. And there are, again, in the First Amendment context, case law context, there are many, many cases talking about what does constitute truly disruptive behavior, and it's not much. It's not, there's one case law where someone engaged in a Nazi salute of the mayor, and the court said that wasn't enough to have that person removed. How do you deal with this? We'll get to it in a second, but how do you make sure that members of the public, in exercising their right to be heard at these meetings, don't take over the meeting and prevent you all from getting any business done? We'll talk about that in a bit. Okay, meetings, as I said at the outset, have to be open and public. What does that mean? Well, the very first thing is that you have to give the public notice of the meeting. The public has to know what you're going to be doing. So cities must post an agenda in advance that contain a brief general description of items to be discussed. As I said before, so that's 72 hours advance posting for a regular meeting, 24 hours for a special meeting. Posting has to be on the city's website. It's also posted at designated locations around the city. The Brown Act says that only a brief general description is required, and it goes further to say that generally you don't need to use more than 20 words for any item. I will tell you now, be very careful and distrustful of that. That's not a sort of get out of jail free card for a meaningless agenda description. The agenda language, as the courts have said, the agenda language considered as a whole must give the public more than a clue. Now, what does that mean in real life? Well, I've seen, not so much recently, because I think most city attorneys and most city clerks know their business and know what they're doing, and work with department heads and city management to get it right. But it means more than an agenda item that says approval of conduct AB 3940. What you want to be thinking about, does anybody think that an agenda item like that gives the public more than a clue, gives them something meaningful? The way I kind of try and think about it is, well, the answer to that is no. The way I try and think about it is the agenda should be such that if a constituent, a member of the public, is sitting at home, they're going to look at that item and say, hey, I care about that. I'm willing to put my shoes back on and my coat and go back down to City Hall and weigh in on that because it's something that matters to me in my life. So the agenda, be careful, just keep an eye on your agendas to make sure that the information provided is meaningful. Okay. Open and public also means that you may not discuss anything that is not listed on the agenda. There is, I'll get into it in a second in further detail, but there are rules and exceptions that apply to that. But basically, you're in a position now where folks in your community know you, and they're used to being able to come up to you on the street or in a coffee shop or at your house and say, hey, I want to talk about this stuff. And now that you are acting as a board member or a commission member or a council member, you cannot do that anymore. The Brown Act really clips our wings in that respect. There are ways that you can respond that are courteous and meaningful to members of the public, but you cannot discuss anything at those meetings just because a member of the public comes up and says, hey, I got a real parking problem. I got a real short-term rental problem. There's a Little League issue that needs to be addressed. If it's not on the agenda to discuss, you can't do it. Finally, the Brown Act allows for public comment, and we'll talk about that. But every agenda has to allow an opportunity every regular agenda has to allow an opportunity for, one, general comment on anything within the subject matter jurisdiction of the city, and two, the public has to be allowed to talk about any item that's on the agenda. There are issues that come up about agenda-related materials. And one issue that was addressed in a recent piece of legislation, Assembly Bill 2647, deals with the situation of this. Typically, agenda materials will be provided to not only to the legislative body, but to the public roughly at the same time as the agendas are posted, 72 hours in advance. Frequently, however, it will happen that additional or supplemental or materials will be provided or will need to be provided to the legislative body after the initial posting period, after the initial materials are sent out. These are often corrections to staff reports, additional supplemental materials, explanations, etc. There was a case that came down in 2021, the Sierra Watch case I have up on the screen, that said you can't do that. You can't provide the materials to just the council members where they're not available to members of the public. And that was, for example, the materials were available to the public, but City Hall was closed and members of the public couldn't get to them at the same time. AB 2647 addressed that and said, you can distribute the materials later or subsequently, such as updated staff reports, proposed agreements, etc., as long as those materials are also immediately available on the agency's website. So that's a change. And that again is an issue of how do you make the meetings open and public, and making meeting materials available to the public is a vital part of the open and public meeting process. Okay, I said before that you can't talk about anything unless it's on the agenda. Here are the exceptions. A legislative body, so you can briefly respond to public statements and questions. You can ask a question for clarification. You may make a brief announcement. You may make a brief report on your activities. You can provide a reference to staff or other sources for factual information. Or you can, this is the important one, you can request that staff place a new matter on a future agenda and report back to you in a subsequent meeting. Be very careful about not viewing these exceptions as, again, as kind of a big loophole to drive a truck through. Brief means very brief. I litigated a case for the city of Culver City a few years ago that involved this very issue, where a member of the public came up at a meeting, asked a question, and city council engaged in a very brief conversation all about, not about the policy, but about factual issues. And that discussion lasted no longer than 6 minutes. And I won the case and the city won the case, but it was not an easy win. It was, the court had to be convinced. And so don't view 6 minutes as a bright line rule, and really, try to restrict yourself at these meetings to the basic rule that says if it's not on the agenda, you can't talk about it. Really, your best course is when a member of the public comes up, or if some new issue comes up, you simply say, let's get this on the earliest possible next agenda, so that we can talk about it. And you can apologize to members of the public and say, hey, we would love to talk to you about this, but state law says we may not. Okay, rules on public participation. Obviously, wherever you're conducting your meeting must be open and accessible pursuant to ADA standards. There must be access to agenda materials, as I discussed previously. The public has to have an opportunity to speak on agenda items and on matters within the body's jurisdiction. By the way, that opportunity to speak on general items does not apply to special meetings, but there won't be many of those. The public has the right to record meetings. Now, they don't have the right to do it if it's disturbing the meeting and interfering with it. But generally, anybody on a a smartphone now can record, and they have a right to do that. They don't have a right to shine a light in your eyes through the entire meeting. Query, and I think case law is going to be the only way we decide this, whether there's a right to have the light on for some small period of time. I think they do. Finally, there additional time has to be provided for non-English speakers. What does it mean, by the way, for the meeting to be open and accessible? We'll get to that a little bit more, but basically, if you're proposing to conduct your meeting in a place where that is not ADA accessible, i.e. you can only get there by stairs, then you can't do it. You cannot conduct the meeting or any part of it. Here's an example, a true example of that came up in the headlines. Agency flouts the law, lock the doors, elevators, keep citizens from agency meeting. The meeting was generally held in a place in a room that was on the second floor, accessible by both stairs and an elevator. The elevator went down the night of the meeting. And the city went ahead and conducted the meeting anyway. That was a violation of the Brown Act. Don't do it. Okay, as I said, there can also be informal meetings that don't involve a majority of your legislative body being in the same room at the same time, and that is informal meetings. Now, what the Brown Act says is a majority of the members of a legislative body shall not use a series of communications of any kind, directly or through intermediaries, to discuss, deliberate, or take action on any item of business that is within the subject matter jurisdiction of the legislative body. What this is mainly referring to, not the only thing, but what's mainly referring to are what we all know as serial meetings. Serial meetings take two forms. One is the daisy chain, the other is the hub and spoke meeting. The daisy chain is familiar, I think, to anybody. If member A contacts B and so forth, and B contacts C, until a quorum has been involved, this is a serial meeting, and it is a violation of the Brown Act. The other one is the hub and spoke. That's where a majority of the legislative body is using an intermediary to develop a collective concurrence. Now, be careful, because it's not a get out of jail free card. There's no loophole by saying, well, we weren't trying to develop a collective concurrence. If the intermediary is and you are passing information back and forth, but nobody's saying, hey, how are you voting? Or let's all get together on this, that still is a violation of the Brown Act. Typically, the intermediary, it can be a city staff person. It can be a private citizen. There are rules that I'm going to get to in a moment that allow intermediaries, allow you to meet with third parties, including city staff or members of the public, but there are rules that limit how you do it. You can't use, under the hub and spoke serial meeting, you cannot use an intermediary if you're going back and forth to develop a collective concurrence. All right, in addition, use of technology can constitute a meeting. Use of email or other technology will violate the Brown Act. The most obvious example of this is email. If you are sending emails back and forth and you are involving a majority of your board or commission or council, that violates the Brown Act. That's a meeting. There is a new social media rule, relatively new, that was adopted, AB 992. It applies through January 1 of 2026. It will probably be continued. We'll see. AB 992 prohibits even one member of the legislative body from responding to any other member's social media posts. So, and what it says is a member of the legislative body shall not respond directly to any communication on an internet-based social media platform regarding a matter that is within the subject matter jurisdiction that is made, posted, or shared by any other member. This is new because, as you'll recall, the basic Brown Act rule requires for a meeting that there be a majority of your board or commission. This now, for the first time, imposes a one-person, one-on-one prohibition. There are no exceptions. It applies to just one response. Now, how does this play out? Well, let's say we're talking about Facebook. If one member has posted something and another member simply likes it or posts an emoji, that is a violation of AB 992. Very restrictive, very new. Here's a hypothetical. Which of the following is a violation? You post on social media and you're the only one other member responds with comments. Well, that's a violation. What if one member likes your post? Again, that's a violation. One member posts a smiling face or some kind of an emoji or other response in response. That's a violation. All of those are violations of AB 992. Now, many people ask, does this mean that there is a sort of first on rule that prevents any of you from using social media to post? The answer to that is no. You just have to be careful not to be posting in response to any other member. Recommendations for email technology. Some of this is just common sense. Avoid sending emails to the entire body. If absolutely necessary, and I would really caution you against doing it, just provide information. Don't try and give your thoughts or views on it, and don't solicit a response. Be very careful responding to emails. Make sure whether other members of your board or commission or council are on the email thread. Don't communicate your position or make a commitment on a pending matter. That can also implicate other fairness principles I'll get to later in the presentation. Do not direct a reply to a majority. Never hit reply all. The other thing that's not really legal advice, but it's advice that's practical and comes from a place where I've seen it happen. Remember that any email you send, or most any email you send about city business, can be forwarded to others, to a majority of the body. And also remember that, and I'll talk about this more later, most of these emails, all of them, if they involve city business, are going to be public records. And the internet has a very long memory. I've seen public records requests coming in from members of the public, and typically they will be people who are angry at you for doing something they disagree with, or it'll be from the press, and the press will simply be doing its job in trying to find out what's going on, how city business is being conducted. And I've more cases than I want to remember have had to respond to city council members or board members who ask me, wow, this is really embarrassing. Do we have to provide it? And the answer to that is yes. So again, think before you send an email. Emergency meetings are another meeting allowed under the Brown Act. I'm not going to spend a lot of time with them, but the Act does allow them, and the noticing is much shorter for emergency meetings. Don't try to, simply because something has to get, you think something has to get done in a hurry, don't try to sort of square peg a non-emergency situation into this exception. Okay, I talked previously about individual meetings and how they can sometimes be okay, even and not be serial meetings. One thing that happens is typically a city employee or official, your city manager or your community development director, whoever is staffing your committee, has an explicit right under the Brown Act to engage in separate conversations or communications outside of a meeting in order to answer questions or provide information. Now, here's the kicker. So long as that person does not communicate to members of the legislative body the comments or positions of any other member or members. What this is these are the informational briefings, typically. And they're okay under the Brown Act as long as you're not counting votes or trying to pass along information regarding or to other members. Let me also say that there is, I can't remember whether I've got a slide for this later, there is also the right to have third-party meetings under similar limitations with members of the public. Now, this will often happen when some member of a stakeholder team, maybe a project applicant or developer, or a neighborhood group wants to meet with members individually. Those meetings are okay. Those meetings are legal under the Brown Act as long as the person does not communicate to members of the legislative body the comments or positions of any other member. Now, there's another limitation about this I'm going to get to, where if you are dealing in what is known as a adjudicative capacity, and some of you will. There are sometimes that, for example, a planning commission or a city council, when it's ruling on, it's acting as a judge, ruling on a use permit or a tentative map or some other adjudicative matter, then certain fairness principles come into play, and these kinds of comments can be deemed to be ex parte communications that for which there are limitations. I know the city of Carmel has its own council policy that applies to ex parte communications that I'll talk about in a bit. Certain meetings are deemed to be non-meetings under the Brown Act. Attendance by a majority of members at a conference related to the business of the agency. This is the typical sort of League of Cities meeting or conference or planners, the APA conferences that you might be attending. You can't use that, however, as a means for a majority of the members to talk among themselves about business of a specific nature within your agency's subject matter jurisdiction. Attendance by a majority of members at an open and noticed meeting of a standing committee, same rule applies. You can't talk, well, here, for this exception, you have to stay quiet. You can't participate at all. You have to attend only as observers. Another one that I don't have a slide for up is you can attend meetings of another body of your agency as long as you are careful not, again, to talk among yourselves in the audience outside of the meeting. Here is a slide I thought I had. The individual contacts with any member of the public, those are okay as long as you're, again, not trying to tally votes or convince any other member through this intermediary. Okay. The Brown Act allows for closed sessions. Closed sessions probably aren't going to matter to you ever unless you're a member of the city council, but I will go through them briefly. Closed sessions are an exception to the rule that agency meetings must be open and public. Only topics that are authorized under the Brown Act may be discussed in closed session. The most common sessions are litigation, real estate negotiation, personnel matters, and labor negotiations. The reasoning behind this, the reason the legislature created it is pretty obvious. If public agencies had to negotiate on litigation settlements or real estate negotiations or labor negotiations, they would only pay the highest possible amount, that there could be, because the negotiating adversary would know exactly what the public agency's position is. Members of typically city councils are prohibited from disclosing confidential information heard during the closed sessions. Now, you can only discuss in closed session things that are explicitly allowed. You cannot discuss anything else. You can't use the closed session as an invitation to more broadly discuss matters that are not, appropriate for agendizing as a closed session. Here's a headline that came up in one case where that rule was violated. The only people who can attend a closed session are the people who need to be there. There is no such thing as a semi-closed session. You can't bring your adversary into closed session to conduct your negotiations. Typically, you'll need legal counsel and necessary support staff in those meetings. Brown Act violations are serious. Any action you take can be invalidated. There could be a civil action to prevent your future violations based on your past practices or conduct. The city will be on the hook for substantial costs and attorney's fees, and I mean substantial. And I think of interest to all of you, it's possible that where the Brown Act allows that for criminal charges to be levied against you, where the member intends to deprive the public of information to which the member knows or has reason to know that the public is entitled to that information. You're guilty of a misdemeanor there. That's it for the Brown Act. I am going to now turn to the other transparency law under California law, the Public Records Act. Access to public records under the Public Records Act is a constitutional right. The Constitution was amended I believe in roughly 2008 or 2009 to make the rights that are available under the statute, the Public Records Act, now a constitutional right. What is a public record? It's any writing containing information relating to the conduct of the public's business, prepared, owned, used, or retained by any state or local agency, regardless of physical form or characteristic. So a writing means something in electronic format as well. If the city is storing something on its computers, that does constitute a writing subject to disclosure unless it's otherwise subject to an exception. The exceptions under the Public Records Act include preliminary drafts that are not ordinarily retained. In other words, if somebody writes something, then deletes it immediately because it's not what they want, or handwrites it and puts it in the trash can, that is not a public record. Records relating to pending litigation are exempt, obviously. Personnel, medical, or similar files are exempt. Attorney-client communications are privileged and thus exempt. And then there's a catch-all under the Public Records Act that says any item for which the public interest in disclosure is outweighed by the public's interest, the city's interest in non-disclosure, is exempt. I can tell you, as a guy who's litigated a bunch of these cases, that catch-all is very, very seldomly applied successfully. Don't look at it as a way to avoid disclosure. Because typically the courts deem writings that contain information about the public's business to per se outweigh the city's interest in non-disclosure. So that really is not often a successful means of avoiding disclosure in the Public Records Act. Now, what about your personal devices and the information stored there? It was, for a long time, the position of cities and the League of Cities that any communications stored on your personal devices even if they related to city business, were not subject to disclosure because they did not satisfy the definition of a writing under the Public Records Act, for the very reason that public agencies don't control those devices or the documents contained on them, the communication retained on them. That was tested by by transparency advocates, and it was tested successfully in the case of City of San Jose versus Superior Court. There, the California Supreme Court said city employees or officials' communications about official agency business may be subject to disclosure as public records, even if the employees or the officials use personal email or text messages and personal accounts and their personal devices in their preparation or transmission. This was a huge sea change, and now you cannot say that something is exempt from disclosure simply because you sent it on your personal computer or your personal smartphone. Now, whenever a city gets a Public Records Act request that asks for your texts and your emails, your city clerk or your city attorney will be contacting you to arrange for you to transfer those documents for evaluation about whether they're otherwise exempt. They often won't be, but now all those documents are in play. Now, not every document on your personal devices or your personal accounts will be a public record, of course. The new test is, does the communication relate in some substantive way to the conduct of the public's business? Or is it, by contrast, is it primarily personal? The factors to consider are the content, the context, the purpose of the communication, who the audience is, was the individual acting with the scope of their employment or office when they created or sent that communication. I mean, I think typically if you are exchanging information about your son's or your daughter's game or you're exchanging recipes, or you're engaging in communications that have nothing to do with city business, then of course those documents are not subject to disclosure. You want to avoid these bad headlines. I'm not going to spend a lot of time on it, but if you violate the Public Records Act, you will pay attorney's fees. Often it will happen, and firms like mine represent cities in Public Records Act disputes all the time. And often it will happen that the request will entail hundreds of thousands of city documents spanning many, many years. And the public has a right to do that for any reason. And the city will make a really good faith and indeed valiant effort to provide everything. And all those documents have to be reviewed. And sometimes documents either get missed or incorrectly classified as falling within an exception and therefore not subject to disclosure. In those situations, the city will pay attorney's fees to the other side, even though some very small part of an otherwise voluminous disclosure fell within the act. So it's a very difficult act, and cities have to take disclosure very seriously. And your city clerk already has a good process for complying with these requests, and they come in. Just as an aside, does it mean that a Public Records Act requestor has a right to effectively close down City Hall by making such excessive and huge demands? No, it doesn't. The Public Records Act does have a means of reasonably responding to requests while at the same time allowing city business to continue. Another headline I'm not going to get into for time purposes. And the Public Records Act was renumbered a few years ago, nothing that we need to focus on here. Little pop quiz. Which of the following is a public record subject to disclosure? A message sent from a city email account. B, a message about city business sent from your personal email account on your personal device. C, a message about city business sent from your personal email account using a city device. D, all of the above. E, A, and C. Well, if we were in the same room together, we could do this, but the answer is all of the above are public records subject to disclosure, all of them. That is it for government transparency, that part of our training today. I'm going to get now into personal financial interests and fair processes. First, I'm going to take a sip of water. Why are we talking about this? Well, public officials owe a paramount loyalty to the public. Personal or private financial interests should never be allowed to enter into your decision-making process. You should not expect to receive any personal gain as a result of your public service. Remember, as we're going through this, that conflicts of interest are not just financial conflicts. And also just remember, again, we're not, I'm giving you these rules as floors, but, you really can do better. And we ought to strive to do better. Perceptions matter. I've seen over the course of my career, the level of public anger and distrust has gone way up. The public often distrust what we do. These rules are in place so that we can try to restore public trust and elevate the public trust. So just saying, well, I've complied with the letter of the law may not be enough for you. So you should really bear in mind whether your participation, even if legal by the these floor rules that I'm giving you, whether it's in increasing or restoring public trust in what we're doing as government. Statutory conflicts of interest rules come under the Political Reform Act and also under Government Code Section 1090. Both are now enforced and construed by the FPPC in Sacramento. I will tell you, and I'll tell you this again, it really is. The FPPC website is extremely helpful, and they have many, many resources that address all of these issues. And I'd encourage you to go there if you ever are browsing and have a moment. You can really get a flavor for what these rules do and how they are covered by the FPPC. Recognizing the need to seek advice. Again, as I said at the outset, in this area particularly, recognizing potential conflicts early is really important. So in a way you can do that, many cities will allow you to talk to staff or whoever is setting agendas for your board or commission or council early on to see what kinds of matters are going to make their way to you in the next few weeks or months. It's important to do this because these issues are very complicated. And in many cases, it's not going to be enough to, take the city attorney aside as you walk into a meeting and say, hey, as it turns out, I own stock in this company, or my wife owns, this piece of property. It's not my name, but it's within 700 feet of the business for which we are granting a permit tonight, or like that. These rules are complicated. They require some analysis. Talk early on with your city attorney, and also consider getting advice from the FPPC. As I said before, your city attorney's advice, while helpful and usually spot on, thanks, it's not going to insulate you from enforcement if that advice is incorrect. Only by getting advice from the FPPC can you insulate yourself from enforcement and liability. Okay, at the outset, these rules, the Political Reform Act requires that we all disclose our financial interests. We do so by statements of economic interests, the famous Form 700. Those of you who are already on boards, commissions, or councils will have already done this probably more than once. The purpose of the Form 700 is to alert officials, alert you of any personal interests that might be affected by your decision making, so that you can decide whether you are required to or should recuse yourself. It's also, the purpose of these forms is to inform the public about your potential conflicts. These forms are public records. The public has the right to review them so that they know exactly what your financial interests are, subject to the conflict of interest rules. The who, what, when, and where of disclosure. Who? Well, all of you, all designated officials under 87-200. Cities, by the way, are required to adopt their own conflict of interest regulations. What those accomplish is to designate what positions in your city are subject to the Form 700 requirement. What has to be disclosed? Specified interests in real property, investments, business positions, sources of income, and gifts. When do you have to do it? Well, when you take office every year by the beginning of April, and upon leaving office, typically you will file these with your city clerk, coordinate with your city clerk for sure, and where, again, you do that with your city clerk, with your local agency. All right, so you've already disclosed, can you participate? Under the Political Reform Act, the general rule of disqualification is this: a public official may not make, participate in the making, or influence. Now, all three of those are in play, and they all involve different kinds of participation. You may not make, participate in the making, or influence a governmental decision that will have a reasonably foreseeable material financial effect on the officials or his immediate family's financial interests, and that effect is distinguishable from the effect on the public generally. Recognize here, you have to consider your immediate family's financial interests, not just your own. And this includes, by definition, your spouse and dependent children. The FPPC a few years ago, I guess it's not more than a few now, adopted this four-part test. Is it reasonably foreseeable that the decision will have a financial effect on the official's economic interests? Reasonably foreseeable doesn't require certainty, by the way, under, excuse me, 50 years of FPPC rulings. Will the effect be material? The FPPC has tests for both foreseeability as well as materiality. Those are complicated tests in many cases, and giving you another reason to coordinate with your city attorney and or the FPPC well in advance. Is the effect indistinguishable from the effect on the public generally? The FPPC also has rules about this. We'll discuss it in a moment. And are you participating in the making, or attempting to influence the decision? The FPPC defines all of those. You know, typically, most obviously, making a decision is voting at a meeting on something. Participating in the making means you're having something to do with it behind the scenes other than voting. And influencing, well, that's a situation where, for example, you might call city staff and say, hey, what do you know about this? And, do you know this? And you can't do that if you have a financial interest subject to these rules. Okay, what are your potential economic interests? Well, you have an interest in a business entity um, in which you have at least $2,000 in which you have a direct or indirect investment worth at least $2,000, or in which you are a director, officer, partner, trustee, employee, or hold any position of management. Obviously, you can see that some thinking needs to go into these. You have a potential interest, you have a financial interest in your real property. Any real property in which you have a direct or indirect interest of at least $2,000. What is indirect? That's defined by the Act. You have an interest in any source of income to you. Any source of income, including commission income and incentive income amounting to a total of at least $500 provided or promised to and received by the public official within 12 months before the decision is made. Recognize that that's not within the calendar year, that's the 12 months before the decision. Source of a gift, again, within the 12 months before the decision. This number is typically increased according to inflation every few years. Now it is, I believe, still subject to the rule that it's $590 in a gift. We'll talk more about gifts later. Here's an example. I'll give you a few of these. One FPPC enforcement decision. Richard F., a council member, violated conflict of interest laws by voting to obtain nearly a $500,000 state grant to extend a water and sewer line to an area of the city where he owned real property and operated an inn and restaurant. He was fined $4,000. Now, for any of you for whom $4,000 is not a big deal, recognize that that's not all you're going to be dealing with, because often there will be lawsuits against you by others for which you will have to obtain your own counsel. And in addition, you'll be probably retaining counsel to deal with the FPPC when they come knocking at your door telling you that they're considering fining you. Another one, Gregory C. was a member of the San Diego County Board of Supervisors and the Coastal Commission, I believe by virtue of his membership on the Board of Supes. In 2015, his spouse purchased 500 shares of SeaWorld, and he was unaware that she purchased it. SeaWorld had an application at that time before the Coastal Commission, and a member sought to, not Greg, sought to add a condition banning captive breeding of orcas. Greg voted against it, and he was the only one who did. He was fined $3,000. Now, question I always ask, does anybody think that Greg would have been free and clear if he had voted in favor along with everybody else? The answer to that is no. It doesn't matter whether your ultimate vote is against your own interest. You simply, the Political Reform Act simply prohibits you from participating at all if that decision is going to affect in any way, your financial interest. Some exceptions. Two exceptions to potential financial conflicts. There is the public generally exception, and there is a legally required participation exception. You can get into those now. Public generally. Decisions that affect a broad range of persons or interests may be exempted. Now, this slide's a little out of date, but typically it is where the decision will affect equally 25% of all businesses, all real property, and all other interests in the community. An example of this might be sewer rate decisions. This regulation was amended just a couple of years ago to also ease a little bit the public generally exception, where it affects not 25%, but 15% of similarly situated real property within the jurisdiction. I think that the consensus was for many years that the 25% threshold was too high. The other exception is where, and this is very, very rarely invoked, but it can apply if a conflict disqualifies so many of you that there's no longer a quorum to make a decision. In that situation, what do? Well, you literally, you have to find some random way of determining which of the otherwise disqualified members get to participate. We've done that. I've done that literally in meetings by having members draw straws from my hand, and the one who picks either the longest or the shortest straw participates. Note that this exception does not apply if a quorum can later be met. For example, if you know that a member is away for the first part of the meeting, but may attend later, and it can't be used to break a tie vote. So what do you got to do if you're disqualified? If you are disqualified, you have to state from the dais, from the platform where you're sitting, what you have to identify the applicable interest with specificity. It's not good enough to say, the FPPC says I'm disqualified, or the city attorney says I've got a conflict. You actually have to say, I have a conflict because I own real property that's located within 500 feet of the project that's before us tonight, like that. You then have to step down from the dais and leave the room. Now, that requirement of leaving the room and stepping down doesn't apply if the item is on the consent calendar. Finally, and in that situation, you still have to abstain from the vote. And finally, you have to refrain from any discussion or participation on the matter that affects your financial interest. Exception, you may participate as a member of the public from the audience on matters affecting your personal economic interests. What that means is that if you have an application in front of your city for a use permit to add a bedroom to your house or something of such, you have a right to sit in the public like any other private applicant and make your pitch to the planning commission or city council. You don't have a right, by the way, to sit in the audience and signal members of the, make eye signals or hand signals to members of the board or the council, obviously, and that's illegal, and it also makes us look terrible when we're trying to increase the public's trust in our process. Another FPPC enforcement decision. Robert, a member of the city council, attempted to use his official position to influence a governmental decision in which he had a financial interest by speaking before the planning commission regarding the approval of an application for the subdivision of land owned by a client. He was fined properly $3,000. That didn't fall within any exception. He was influencing and using his official position to influence a governmental decision in which he had a financial interest. Okay. Separate and apart from the Political Reform Act, there are rules that apply to us by virtue of what is known as the common law. Typically, this is law that has been created over many years in this country through case law and decisions by administrative agencies. And under this rule, personal interests or biases, positive or negative, about the facts or the parties may cast doubt on your ability to make a decision. You need to exercise the powers that have been vested in you with the appearance, at least the appearance, of disinterested skill, zeal, and diligence. These words are taken from case law. Okay. Those common law rules very often will not apply because the statutory rules do apply and other rules, but they're still in play and worth being aware of. All right. In addition to the Political Reform Act, you are also under subject to the rules governing contractual conflicts of interest under what is known as Government Code Section 1090. At its heart, Section 1090 prohibits officials and employees from having financial interests in contracts made by them in their official capacities or any board of which they are members. The rule, as I said, is that. It prohibits contractual self-dealing. Now, what is a contract? This is something that's important to know. A contract is not just a formal written contract that a city signs. Rather, the Attorney General and case law have recognized that contracts can exist for purposes of Section 1090, where the government is making certain funding decisions. And that can apply to grant funding for nonprofits, for example. So it's important to be aware of that because you may have an interest in that nonprofit by virtue of the statute. And just because the nonprofit or other entity is receiving funding but is not entering into a formal contract, that doesn't matter. It still will apply in that circumstance. The application of Section 1090, it applies to virtually all city commissioners, officers, council members, and employees. It involves any financial interest. Remember that when we were talking about the Political Reform Act, there were certain limits that applied to the financial interests. Your interest had to exceed $2,000 for certain interests under the Political Reform Act. That is not the case under Government Code Section 1090. The 1 penny rule applies. If you have a financial interest of even 1 penny, that's enough to implicate Section 1090. Very strict, obviously. It's an absolute prohibition. It doesn't allow abstention. Go back. Section 1090 does not allow the agency to continue with approving the contract simply because an individual member with the conflict has recused or abstained. The conflict, if it exists, extends to the entire city, and his or her participation is presumed. What does that mean? It means that the contract may not be entered into if even one member or one employee has a financial interest. Now, there are exceptions. There is a rule of necessity exception, or if the financial interest is deemed to be minor or remotely involved. This is a very draconian statute. The consequences of a Section 1090 violation are very serious. First and foremost, the contract is deemed void and unenforceable. In that situation, the official who has received any money has to return that. By contrast, if the city has received any benefit under the contract before the contract has been invalidated or deemed void, the agency gets to keep everything it's received, any benefits received under that contract. For you ought to be aware that the violation is deemed a felony if it's willful. You're subject to fines, imprisonment, and a lifetime bar from holding office in California. As I said, it's a draconian statute. Now, it doesn't always apply. The legislature has created exceptions for what it deems to be either remote interests under Government Code Section 1091. One example is a landlord or tenant of a contracting party, or, a non-interest. One example is a non-compensated officer of a nonprofit under Section 1091.5. The legislature has created dozens and dozens of these exceptions, either under the remote interest exception or under non-interest. If you have such a remote or non-interest, you still must abstain from voting, but the city may enter into the contract once you've abstained. I'm not going to get into all of these here. It would take up the rest of our time, but it's important for you to get legal advice early on if you think you may have some interest in an entity that is seeking funding or a contract with your city. Okay, that's Government Code Section 1090. We're now going to get into other fairness and process laws that will or may affect your public service. These are procedural due process is a constitutional concept. It also gets to fair hearing rules that can apply that are similar to due process, but they're imposed by statute. Public bidding requirements under the Public Contract Code and under certain applicable to certain grant requirements under federal regulations regarding procurement, non-discrimination requirements, and embezzlement rules. I don't think we need to spend a lot of time delving into embezzlement under the penal code. So due process rules and fair hearing rules that will apply. Here's when I was referring earlier to some of you and some city boards and commissions will, under some circumstances, act in what are known as adjudicative or quasi-judicial proceedings. You act as a judge of sort. In those, and the examples again are those of you who conduct hearings to grant entitlements. The most obvious example will be a city planning commission or architectural commission giving an architect, granting an architectural permit or approval, or the planning commission granting a use permit or tentative map. Those in those situations, cities are acting in a quasi-judicial manner. And in those circumstances, are subject to due process requirements and fair hearing requirements by statute. Here, the statute is Code of Civil Procedure, Section 1094.5. And if the decision involves a vested property interest or a liberty interest, this would be applicable, for example, to certain employees who have disciplines being appealed in front of one of your boards or commissions. Those hearings are subject to due process requirements. So what are these due process requirements? Well, at their heart, they require proper notice. The stakeholder has a right to know when and how a decision is being made affecting their rights. They have a right to present their case. They have a right to speak to you, much as a person who is before a court has a right to have their voice heard. They have a right to fair and unbiased decision makers. And there are rules applying to all of these principles. The other thing is that within the proper notice requirement is this issue of ex parte information that I referred to earlier. If you are typically, when you are acting in this quasi-judicial manner, you're acting as a judge, everybody who is there has a right to assume that you're only making your decision on the basis of the evidence you are hearing that everyone else is here at the public hearing, at the meeting. So the rule has been created over the years that you may not consider evidence that you've heard outside of the public hearing. And that is why many cities have adopted rules that prohibit ex parte contacts. The city of Carmel has a city council resolution adopted back in 1989 that essentially suggests that council members not engage in ex parte, not receive ex parte communications or evidence. It's written in a way, however, that is fairly vague. I believe the city council has adhered to that over the rule, although I would defer to all of you, your city clerk and your city attorney, because I don't sit with you week in and week out. But that council resolution does not apply to boards and commission members. Now, I don't know whether you all are adhering to those rules in every instance, but for those cities who do allow ex parte communications, and they're extremely common, these due process and fairness requirements nevertheless require that you disclose all of those ex parte communications and all of the evidence you viewed outside of the public hearing. You have to disclose them at the outset of the meeting. And the reason for that is it's giving proper notice to the stakeholders that they may need to respond to those, to that ex parte evidence and those ex parte communications. Important requirement that applies, again, when you are acting in this adjudicatory manner. You have to be fair and unbiased. The rules are such that this doesn't require that you not have any opinion or that you not have heard any facts in advance. But what it does require is this, that you commit to not making a decision in advance of the public hearing until you have heard all of the evidence at the public hearing along with everybody else. Often how this plays in a small community is this. You'll run into your neighbors and your friends who will say, hey, what do you, I know that this development project is coming in front of you next week. What do you think about it? These rules don't require that you keep your mouth shut. What they do require is this, that if you are inclined to respond, you can perfectly naturally say, I do have concerns about these issues, but I'm not making up my mind until I've heard all of the evidence at the public hearing. And that is, the purpose of that is to give the public some trust that this is a fair process and that you are not, you're maintaining your fairness and your lack of bias until everybody's had a chance to weigh in. Now, these requirements do not apply to purely legislative actions. Again, as I said, they apply only when you're acting as a judge. So, for example, if you're adopting a new policy that doesn't involve an individual stakeholder or applicant, these rules don't apply because the law says that deems that you are acting in what's known as a legislative, not a judicial capacity. Other rules that apply, there's a rule that prohibits the simultaneous holding of two public offices. Now, this is a law that came up from actually Old English common law, has made its way up to us through the common law. It's now embedded in a statute in California, in Government Code Section 1099. At the heart of the rule is this: you may not simultaneously hold what are deemed to be two public offices. And if you're in a city board or commission, or if you're on the city council, you hold one public office. Now, you may not hold a second if one office exercises a supervisory, auditing, or removal power over the other office. Two, there is a significant clash of duties or loyalties between the offices. And three, there are public policy considerations that make it improper. Now, recognize that the case law under this doesn't require that there be an actual clash of duties or loyalties. Rather, it's sufficient if there is a theoretical clash that can be imagined between the two offices. There are hundreds and hundreds of opinions written by the California Attorney General addressing these issues as to whether offices are incompatible. The obvious examples are if you're sitting on the city council and someone asks you to sit on the county planning commission. You probably can't do it. I'm almost 100% certain that I've read AG opinions on that one, but there are, as I said, hundreds of these opinions addressing a variety of different offices. A public office, by the way, is not an employment. So there's a difference between a job on the one hand and a public office. These are issues to talk with your city attorney about. Recognize that there is a very steep downside here. The consequence of holding an incompatible office is that the person is deemed to have forfeited the first office upon acceding to the second office. So it's a bit of a gotcha. There are procedures that will prevent that from being, an automatic gotcha. There are protections for the public official and ability to argue the points, but just recognize that forfeiture of office is important. So before you accept that second office, think. This rule is inapplicable where holding the second office is specifically authorized by statute. And this happens all the time. So it doesn't apply also to a position of employment, as I said, including a civil service position. It doesn't apply to a governmental body that has only advisory powers. And it doesn't apply where the member of a multi-member body holds an office that may audit, overrule, review members of, or dismiss employees when the body has any of these powers over the other office. I'm kind of tripping over my words here. Okay, legal limitations on personal advantages and perks. First one we're going to deal with is expense reimbursement. From time to time, you may be incurring expenses as part of your duties, and those expenses may be reimbursable to you. The general rule is the only expenses that are reimbursable to you are your actual expenses and your necessary expenses. Now, this is pretty intuitive, I think, that you ought not be seeking reimbursement for expenses that you didn't incur. And also, you ought not be seeking reimbursement for expenses that are not necessary. I don't remember, Nova can clear this up for us, whether the city has adopted reimbursement policies. I believe most cities have and are required to. You are typically required to timely use report forms that your city requires with receipts documenting all of your expenses. Sometimes you will be required to orally report at a subsequent meeting what your expenses have been. This is only for attendance at Brown Act meetings. And there is a strict penalty for including loss of your reimbursement privilege, the requirement that you will have to pay back any of these expenses that you've received, restitution. There can be civil penalties and fines of up to 3 times the value of the misused resources. You can be subject to jail for improper expenditure reimbursement, and you can be banned from public office. Again, this is a steep downside. Specific applications of this, often, for example, if you are going to a professional conference, planning conference, League of Cities conference, something of the such, you will typically be required, or you'll be allowed to stay at a hotel designated by the conference. Sometimes officials decide that they don't like the hotel. They want to stay at a better hotel or a more convenient hotel or a more expensive one. Can you recover those expenses? The answer to that is no. You are required to cover those expenses yourself because the city is only required to reimburse you for the expenses that are normally incurred for attendance at that specific conference. Your expense report forms are public records. So You want to get it right. We're trying to to instill confidence in the public, to increase the level of confidence and trust. We want to treat expense reimbursement as a way that we can do this, and you recognize that the public will be reviewing your reimbursement requests as public records. So you want to get those right and not be asking for reimbursement for things that you're not entitled to reimbursement. All right, gifts. Now, as I discussed earlier, gifts are subject to the Political Reform Act. They also have rules that apply outside of conflict, outside of the conflict of interest recusal requirement. What is a gift? A gift is anything of value that you receive for which you do not provide monetary or other consideration of equal or greater value. This may include discounts and rebates if those are not also given to the general public. You are required to report gifts of $50 or more in any year. That's in a calendar year. In addition, there is an absolute limit on receiving gifts from any single source. That limit, as I said before, is indexed, and it goes up every couple of years. It's now $590 per year per source. That means that if someone tries to give you a gift of $591, you are prohibited from receiving it. I'll talk a little bit more about that in a second. That dollar amount became effective January 1st of 2023. It's effective, I believe, through the end of this year. So what happens when you receive a gift over $50? Well, you decide if you want to report it on your Form 700. If you do, report it within 30 days of receipt. If not, then within 30 days, you reimburse the donor for the fair market value of that gift. Don't play games with the fair market value here. You have to make a good faith effort at determining what that is. You can return the gift unused, or you can donate the gift to charity. Now, does anybody think you can take a tax deduction on that donation? No, you can't. If you decide to donate the gift to charity, you may not take the tax deduction. If the gift exceeds $590, you have a duty to reject it. Alternatively, you can do what's known as buying down the value. So you can pay for any amount in excess of $590. You must report gifts on your Form 700 if the total value of all gifts from that source is at least $50. Gifts are reportable regardless of the location of the donor. If the amount of the gift is known, as I said, make a good faith estimate. Now, good faith estimate means just that. Do what you can. There are a lot of tools available, including asking the donor what the fair market value is. Avoid these headlines. The mayor in Los Angeles, mayor and 4 city councilmen were fined for ethics violations for receiving gifts worth more than $100 and tickets to Hollywood's hottest awards shows. The city's ethics commission voted Tuesday. The mayor was fined $20,000, nearly $21,000 by the commission. He had earlier been fined $21,000 by the FPPC. Again, these amounts, high in and of themselves, are not going to include what you're paying a lawyer and what you might pay in a civil action against you. By the way, let me just reiterate that avoiding huge dollar fines and attorney fees is not the sole or even the principal reason we're complying with these laws. Again, it's important to recognize what we're trying to do here is be better public servants and to increase the public's confidence and trust in what we're doing. Okay, our meals gifts. The short answer is yes, a meal is a gift unless it is provided at an individual's home as a part of an existing relationship. What does that mean? Well, that means if a local applicant or developer or neighborhood association chair whom you've never shared a meal with before, all of a sudden invites you to a nice dinner at their home, that you can pretty much assume that that meal will constitute a gift subject to these rules. You really do have to have an existing relationship with someone for this exception to apply. Second, a meal is not a gift if it is provided as part of a reciprocal exchange. If you've got a relationship with someone where you're alternating who's paying, that's not part of it. That's not a gift. A meal paid for by a governmental agency is not subject to this rule. Another FPPC enforcement decision. James, as mayor of Palmdale, I don't know why we avoided his last name since it's pretty easily determinable by the public records. But in any event, Mayor of Palmdale failed to timely disclose gifts of 2 meals totaling $253 and change on his Form 700. All gifts were from E.J. De La Rosa and Company. Penalty was imposed, $200, because of this. In addition, there is the other one below that I'll just pass by. There are other exceptions that can apply to the general gift limitations. Gifts from family members are typically not subject to these rules. Food gifts for an office are typically not subject to the rule. Be careful. If somebody is giving a gift to the office, but it's really controlled solely by, let's say, your city manager or city attorney, that's not subject to this rule. The rule, it really has to be, if somebody is sending, the chocolate strawberries or some donuts or something like that to City Hall, they have to be for the entire office. Finally, trophies and plaques valued at less than $250 are generally not subject to these gift limitations. Prohibition on gratuities or rewards. It's a crime. It's a misdemeanor to receive any kind of gratuity or reward for performing one's duties of office. This is pretty darn intuitive. I think we all know better than doing that. And there's a steep downside if you do it. And it's the worst possible thing to do because it just confirms the public's worst beliefs and assumptions about their government. And we're trying to do better. Back in the early 1900s, when the railroad companies were all important in California, a provision of the California Constitution was added in Article 12, Section 7. It says a transportation company, that's a term of art that we probably won't get into now, but it's all of your major bus lines, rail lines, airlines, like that. A transportation company may not grant a free pass or passes or discounts to anyone holding an office in this state. It applies to all of you if you're on a board or commission or council. The FPPC has adopted a regulation that also prohibits this. Let me go back. The downside here is also extremely steep. It is forfeiture from office if you do it. Now, what if a discount is available to everyone else, to members of the public? A free pass is available on certain days of the week to everybody, irrespective of any office they hold, or there are discounts available to the public. This does not apply to, these discounts do apply to public office holders to the same extent as members of the public, and this constitutional prohibition does not apply to in those situations. Honoraria, receipt of honoraria, which are any payment for speech, article, attendance at a conference, event, or similar gathering, is prohibited. You can't take money. I'm sorry, you cannot take an honoraria, that payment. The exception is if you're giving a speech or article in connection with your private business. Also, you can return or donate the honoraria, but you got to do so fairly quickly, within 30 days of receipt. What's the reason for that, by the way? I think it's pretty obvious. This rule is to try to, again, increase the government's, the public's trust in what we're doing. It just looks and smells bad if we're accepting payments for maybe some, small event, or giving you're being asked to give a small speech at some event. It just looks bad if you're a public official and you're getting paid for those. You can't misuse the public resources. The rule is that no use of public funds or resources may be made for personal, non-public purposes, including campaigns. What are public resources? Well, this includes staff time, office equipment and supplies. It excludes incidental or minimal uses. So if you are a member of a board or commission or council, you ought to avoid using the City Hall copier. Now, there is this exception for incidental or minimal uses, but if you're going in there and using the copier for your personal purposes, don't do it. I would say don't do it even for your incidental or minimal purposes, because it just gives a bad appearance. It looks like you're using your position for a perk that nobody else and no other member of the public is getting. And don't ask staff to do anything. I don't know of any of us who would even, imagine that we could ask city staff to be conducting personal errands or taking care of personal matters for us, but you cannot do it. The penalties are, again, steep. You can be disqualified from office. You can go to jail. There are civil penalties up to $1,000 a day for violations, plus 3 times the value of the use. Almost all agencies have, almost all agencies, I believe the same is true for Carmel, have policies that address these issues, make sure that any use of city resources is consistent with the city's adopted policy or practice. Solicitation of political support. You can't do it. Soliciting campaign funds from agency officers or employees is unlawful. It's against the law. The exception is when this is included as part of a communication to a significant segment of the community. If the solicitation is happening to everybody else in town, that's not part of this prohibition. And obviously, conditioning employment and compensation decisions on political support is prohibited. These may seem like obvious rules, but it's amazing how some people forget them. Gifts of public funds. Very often, agencies, your city councils will give money to private entities. And the California Constitution has a prohibition against local agencies making a gift of public money or anything of value to private entities or people, persons. Expenditures, however, the big exception is that well recognized by the case law, is expenditures for public purposes are not considered to be gifts in violation of this rule, even if a private party incidentally benefits. There are many times public agencies will give public funds to private entities because those funding decisions will have a positive public purpose effect. The courts have also been very deferential to the city councils as to what does constitute an appropriate public purpose. There is a prohibition on certain mass mailings. The rule is this: a mass mailing is generally prohibited if each of the following criteria is met. Delivery: a tangible item such as a newsletter or brochure is delivered by any means, including by transmission of a fax or email or website to a person's residence, place of employment, or business or post office box. 2, the item features an elected officer. The item sent either features an elected officer affiliated with the agency. Now, featuring will be, maybe it could be an article about that person, or it can be a picture. 3, public money is used for the mailing. Any of the costs of distribution of the mailing is paid for with public monies, or if public funds are not used for actual distribution, in excess of $50 in public monies has been used in to design, produce, or print the item. And finally, number 4, mass mailing. More than 200 substantially similar items are sent in a calendar month, excluding any item sent in response to an unsolicited request. Again, this is something that the FPPC has jurisdiction over and will enforce. Here's an example. Here's the public eye. The city of Rockland was fined $2,000 for a newsletter containing prohibited photos. What were those prohibited photos? Rockland was fined $2,000 by the FPPC for blanketing households with a newsletter that contained photos of city council members, which is a violation of the Political Reform Act. City officials said the inaugural letter inside Rockland was a well-intentioned effort to keep citizens informed and that they were unaware of the rules. Well, cities are required to be aware of the mass mailing rule, and this was a real no-no in violation of the rule. There are restrictions on loans. Public officials cannot receive loans from anyone within the official's agency or with whom the agency contracts greater than $500, except in writing and with clear terms. An exception, loans received by the official's campaign committee, normal bank and credit indebtedness, and loans from family members. Enforcement decision here, Antoinette for a city violated when she approved and signed a series of contracts with a contractor who happened to be her former brother-in-law, from whom she had received a loan in the amount of $50,000, $6,500 fine. As we wrap up, some final questions to ask. We've been through these. Think always, as you're making your decisions, as you're exercising the authorities of your public offices, what would inspire the public's confidence? What decisions best serve the interests of my community? Public perception. Even if you are confident about the right thing to do, try not to forget about the public's perception of what we're doing. The public needs to believe that the right thing has been done. There are many resources available. As I said before, check the FPPC's website. You can contact the FPPC at these numbers. The Attorney General has great resources available. Also, there's an arm of the California Cal Cities, formerly the League of California Cities, called the Institute for Local Government. They have many publications available, lots of good information available on all of these topics. There are two good publications available on both the Brown Act and the Public Records Act that are available through the League of Cities, Cal Cities. and many board and commission members and council members that I know carry those with them where they go and at public meetings. So there is a fairly quick resource available to them on these topics. And that's it. You made it. Congratulations. And I'm available, as I said, for taking pictures if that would be helpful. Taking pictures for answering questions if that would be helpful.
If anyone has any questions, just raise your hand on Zoom and we'll just go one by one. And if you don't have any questions, and you're welcome to leave the meeting as well.
Thanks very much. That was a really good presentation. Appreciate it.
Thank you all. I appreciate your bearing with me.
Okay, Donna, you can go ahead and unmute yourself if you have a question.
No question. Thank you. It's actually the time went very quickly, and I've been through these before, but I think bringing up all that information is important. And the public, unfortunately, doesn't know how well our city council is acting. Thank you.
Thank you.
David O'Neill, you can go ahead.
Hello, thank you. This is the first meeting I've been to for this. I really appreciate it. I wanted to clarify something because I'm trying to understand some of the communication between council members and the public. If somebody goes to a meeting as a council member and listens to and gives information and stuff, but then that winds up getting spread along inadvertently somewhere along the way to some other council member or something, how are you going to be able to communicate with the public while still not having that chain?
I'm not sure I clearly followed the question.
Okay, let me describe a situation for you.
Yeah.
We have a group of different people who belong to different associations, and we get together and we talk about different things. And we would like to have somebody from the city council come and participate in those meetings with us to give us information and to listen to our perspectives. Now, if somebody from that meeting goes along and talks to some other city council member and so on and so forth, happens another time, what is our responsibility as far as that's concerned? How do we stop that from happening? Or can we just never have any conversations with groups of people?
Well, you can have conversations with groups of people, and the Brown Act does address those situations. It doesn't address it perfectly, and nothing in the Brown Act can ever, perfectly address all of the situations that arise in any community. But typically, your associations have the right to meet, of course, and less than a majority of your city council can attend those meetings. In addition, if a majority of the council wants to attend, that's not subject to the Brown Act, provided that the meeting is open and public to the entire community and the council members don't talk among themselves at those meetings.
Okay, so just a quick clarification about making it open to the public. Does that mean that it has to be announced through the city hall, or does it just have to be made public through some sort of ad in the newspaper or something?
Yeah, the latter. It doesn't have to be agendized or noticed through city hall. But again, what I'm talking about here is an exception to the meeting requirement. So council members may attend, even a majority may attend a private meeting, a private association's meeting, and then and only then can they, does that exception apply when your meetings are open and public. So if you're not anticipating a majority of the council to show up, you can conduct your meetings any way you normally would. In other words, you don't have to make them open and public. There's nothing in the Brown Act that requires private agencies, private associations to conduct open meetings. The only reason you would ever have to have them be open and public is if a majority of council members want to attend. Then for the exception to apply and for that meeting not to constitute an illegal Brown Act meeting, your meeting has to be open and public, and the council members have to not talk among themselves about any matter, subject to the city's subject matter jurisdiction. Does that make sense, or was that really?
No, that makes perfect sense. Yeah, thank you for the clarification. I have one other quick question.
Sure.
If a council member feels a need to speak at a board or commission meeting, can they do that, or they have to wait for something to be brought up to the council at the council level to be able to discuss something?
My view of that is that the council members do have a right to speak, but they have to do so only in the same manner as the public at that meeting. In other words, if the public has a right to speak, so too does a council member have a right to speak.
And in that way, they would say, I'm not speaking as a council member, right?
Well, I mean, I don't think it's that important that they even say that. The Brown Act, if you read the Brown Act exception for that, the exception just reads that they have the right to attend and participate as the same as any other member of the public. So I don't know whether, and it's not really written in that way, and I don't have the actual language in front of me, but my view of it is that there's nothing there that says I'm not speaking as a member of the council. I think that's a better practice, but it's not necessarily so. For example, often the council will designate a member to go down and sit at at one of their boards and commission meetings. And in that situation, the council member is participating as a member of the public. I mean, sorry, as a member of the council.
Okay. Well, can I ask one more quick question?
Yes, sir.
Okay, thank you. Can you just give me just a little bit of understanding of why personnel files are not public records?
Well, because the legislature has deemed personnel files to be, subject. I'm sorry, that has deemed an employee's has understood that the personnel files contain private matters for which that employee has a right to expect that it won't be made public. Often that will include, for example, disciplines, and it will include medical information. And for those reasons, the legislature has said that those personnel files are not typically available. They were subject to an exemption. There are some exceptions for peace officers now in more recent legislation, but I'm not going to get into that now. But that's one where I suspect that employee groups have had, this is an exception that's been in the Public Records Act probably from the beginning. And I think it's possible that when that law was passed, that exception was passed, it was done in recognition and with assistance by employee groups, negotiating groups, labor unions, et cetera, representing employees, that these kinds of personnel files should not be available for public review.
Okay, thank you. I appreciate that.
Yeah. And that's one of the exceptions on the Public Records Act that is pretty sacrosanct, to the courts. It's very seldom invaded.
Okay, thank you. I appreciate it.
Sure.
Donna, go ahead. You have a question?
Public records, securing copies. Many times you read where citizens ask for public records and they're not provided in a timely manner, if ever. And I do understand some ask for thousands and thousands of pages, but just relevant to what's going on now. So why it seems like the cities and different counties and states do not do it timely? Why?
Certainly, what you've said is what open government and many transparency advocacy groups will say, and do say. And I think it's true in some instances. I will say, as a lawyer who has represented government for 40 years, that I see that the converse is true. The opposite is true. That cities make a really good effort at providing documents timely. Well, I haven't worked with Nova and and Carmel about, on these issues. I have no reason to believe that's not done in Carmel as well. Now, I'm not giving, I'm not advocating now for cities, but I do want to give that other perspective. There are rules that govern how quickly cities are required to respond to Public Records Act requests. In my experience, where City Hall is not particularly busy and where maybe 1 or 2 copies are sought, on a given day, oftentimes those copies are made immediately and provided. In other instances, however, cities will invoke their right under the act, which is, to wait and provide a response within 10 days. Now, the 10-day rule is there because often the request for documents requires somebody at City Hall first to locate the records and then somebody else to review them to see if they are subject to an exception. And that review process, Donna, can be pretty important because cities can get in trouble if they disclose records that are private, that involve, confidential private information. And so, it's kind of a fine line for cities to walk. I know that many people in the public get very frustrated with cities in responding to Public Records Act requests. I can only tell you that from my perspective as a government lawyer, I see that there are pressures on government, both time pressures and pressures to get it right, to not disclose the wrong documents, that will often, drive the need for cities to invoke the 10-day rule. And the 10-day rule really just says under the Public Records Act, we have 10 days to determine whether there are public records to disclose. So even then, it's not a given that the member of the public is going to get the documents they've requested or all of them within the 10-day period. Anyway, I don't know if that answers your question.
Thank you. Thank you.
Sure.
Does anyone else have any questions? Okay. I don't see any hands raised, so I think that wraps up the meeting. Thank you, Tom, for doing this, and I hope you can drink lots of water. You're probably tired from talking.
You're all tired of hearing my voice. Thank you all for listening. I appreciate it.
All right. Thanks, everyone.
Bye-bye.
Bye.